Hello and welcome to Rajya Sabha Television. You're watching a brand new edition of Policy Watch with me, Frank Rausen Pereira. In a huge benefit to millions of private sector employees, Parliament recently approved the Payment of Gratuity Amendment Bill of 2018. After implementation of the 7th Pay Commission, central government employees had not just received salary raises, but the amount of their tax-free gratuity had also been doubled to 20 lakh rupees from 10 lakh rupees. However, private sector employees were as yet bereft of this benefit. The passage of the gratuity bill amendments paves way for private sector employees to avail tax-free gratuity up to 20 lakh rupees. In our first segment of Policy Watch today, we will analyze the merits of the new law. Joining me on the program today are Dr. Onkar Sharma, Deputy Chief Labour Commissioner, Government of India, and A.K. Bhattacharya, Editorial Director of the Business Standard. Thank you to both my guests for joining me on this edition of Policy Watch. Dr. Sharma, I'd like to begin with you, of course. Before we talk about the bill itself and, the law and everything else, let's first talk about gratuity and what exactly is gratuity and how does it benefit the people?
The Payment of Gratuity Act, it came in 1972, applicable to factories, mines, plantation, oil field, ports, railways and shops and other establishments. As per the law, any employee who has completed 5 years of continuous service at the time of termination of employment, maybe because of superannuation or because of voluntary resignation or for any reason, she is entitled to get the gratuity at the rate of 15 days wage for each completed year of service. For 1 day wage, we calculate 30 days wage, that is 1 month wage divided by 26. And this 5 years service is not required in case of death or permanent total disablement.
Sure. Let me bring in Mr. Bhattacharya into the picture now. Mr. Bhattacharya, what changes now that this bill has been passed in Parliament?
What changes is that a facility that was earlier available only to government employees or employees of government bodies is now been extended to private sector employees who are covered under the Gratuity Act. The gratuity is actually one of the many social security benefits under the current dispensation in terms of various policies in force. Now, what happens is that when somebody gets more than 10 lakhs of gratuity, as Dr. Sharma pointed out, he is taxed. So, let's say if he gets 12 lakhs of gratuity, so 10 lakh is tax free and 2 lakh he pays tax at the rate of his, the marginal rate of his taxation. If he pays 15%, he gets 15%, otherwise he pays 30%. So that tax exemption now will be available up to 20 lakh. So which to my mind is a big benefit. But the bigger benefit to my mind is that not many employees are actually have, let us say, completed 5 years of service. They have left a job, they have got their gratuity, they may have got 10 lakh already, so they may have got the tax exemption in the under the previous law. Now you are working for another company, complete 5 years and you leave. If you are not crossing 20 lakh in the second time, you also get the benefit. So to my mind, it is a big benefit. And the second big benefit of this amendment in my view is that the rules have been changed. In other words, that for the next time you need to revise the tax applicability limit for gratuity beyond 20 lakh in keeping with the inflation rate. You don't have to go back to Parliament and amend it.
Yes.
The law has been amended to make sure that the rules can be framed by the central government appropriately to raise this limit, because from 10 lakh to 20 lakh one had to wait for so many years because the Parliament had to approve it, then the President has to sign and make it into act. But
so you're not keeping up with the times.
Keeping with the times. So now what will happen is that anytime the government thinks that inflation has taken place, therefore what was 20 lakh 5 years ago is now less than 20 lakh. So therefore raise the limit so that it is in tune with the inflation rate. So that to my mind is a big benefit of this amendment.
Sure. Yes, Dr. Sharma.
One thing, just to supplement what Dr. Bhattacharya said, the amendment is, that is presently, that is what we are having with the calculation, the ceiling amount, that is ceiling is 10 lakh rupees. Means as on date, employer is not liable to pay more than 10 lakh rupees. This is the, even that is what I have given you the calculation. If calculation comes 20 lakh rupees or 25 lakh rupees or 15 lakh rupees, so employer is liable to pay only up to 10 lakhs rupees.
So it can't go beyond that.
No, he can, but the law, we cannot, under the law, we cannot compel him to pay 15 lakh rupees
Sure.
or 18 lakh
Sure.
rupees. So first thing, that is now, that is the ceiling of 10 lakhs. Ceiling is what we are, what in the proposed amendment is, that now the ceiling is, even that is in the proposed amendment, there is no word 20 lakhs. What is there now? This is, that is, power has been given to the central government. Central government, by issuing the notification, can decide, can fix the ceiling of the gratuity. So generally, what is in the past, before 1997, the central government employees ceiling of the gratuity was 1 lakh rupees. So it was in the Payment of Gratuity Act. In 97, it was enhanced as per the 5th Pay Commission's 3.5 lakh rupees. So the law was amended, enhancing it to 3.5 lakh rupees. In 2010, again the ceiling was enhanced to 10 lakh rupees as the 6th Pay Commission recommended, that is up to the 10 lakh rupees to the central government. 7th Pay Commission, it says 20 lakhs gratuity ceiling. So that is, there is a, that is, the government may fix 20 lakh rupees, and what Bhattacharya has stated, in the future we need not to go to the parliament for getting it amended. Now that is, this proposed amendment is giving the power to government to enhance time to time as wages increases,
Sure.
or inflation increases, or
So
pay commissions.
is there a ceiling now in the amendment?
In the amendment, there is no ceiling. Ceiling is to be notified by the government of India time to time through notification.
Sure, sure. So that could be 20 lakhs at the moment, is what you're
Yeah,
suggesting.
it can, it can be, but it can be 20 lakhs. Because what the past practice is, what the gratuity ceiling in the Payment of Gratuity Act is same what the central government employees get.
Okay. Sure. Yeah, Mr. Bhattacharya, you know, who stands to benefit the most after this amendment, and you know, how soon can we see this benefit being doled out to the common man?
At two levels. At one level would be that all private sector employees as well as the government employees will now, by law, no employer can deny a gratuity above 10 lakh. They can claim it up to 20 lakh. And the second benefit would be, as I said, that the tax liability on above 10 lakh and up to 20 lakh will still be zero.
Zero, yes.
So that is a second benefit. The third beneficiary would be the woman employees who earlier, now if you are, let us say you are going in for pregnancy leave, for now it is allowed up to 12 weeks, and now they are planning to make raise it to 6 months. Now my sense is that this law will now cover, will exclude, you know, if you are away on pregnancy leave for 6 months or 12 weeks currently, for gratuity calculation purposes, this will not be counted, in a sense that you will get the benefit of this pregnancy leave for calculating your gratuity. So in my view, the general employees, private sector employees and women employees will benefit from this in a big way.
Sure. You know, yes, Dr. Sharma.
Just on the maternity benefit, maternity leave, presently what in the beginning I said continuous employment. So then we have defined what is continuous employment, and then explanation is there in the law. What is continuous employment? What is included in the continuous? So continuous employment doesn't mean physically the employee is attending every day. So the woman who is on maternity leave, present law, it says 12 weeks. they will be treated, that is, if she is on the maternity leave up to 12 weeks, these 12 weeks are treated as in the employment, continuous employment, for the purpose of eligibility. Now, Maternity Benefit Act has been amended, given the effect from the April 2017,
Yes.
enhancing the maternity leave from 12 weeks to 26 weeks. Here in the explanation, we are rewriting the explanation, that again we are not putting, we are removing 12 weeks, we are not even putting 26 weeks. Again, that is, central government will notify what will be the maximum maternity leave, which will be considered as in the continuous employment for that woman worker. So, yes, that is present because Maternity Benefit Act has been amended, increasing to 26 weeks. So, we thought of amending this explanation, rewriting this explanation, that government will notify time to time.
And just for the benefit of the viewers, you know, what does sick leave also
Yes,
come under
sick
this?
leave.
Yes.
See, in the explanation, if you see what is continuous employment, any employee who is on the leave, any kind of the leave, is treated in a continuous employment, except when there is a break in service. Even leave without pay, she is considered as in the continuous employment, unless that is standing orders provide, if someone remain absent without pay and there is a provision of break in service, then she is not treated in the continuous employment.
Sure.
So, sick leave, earned leave, maternity leave, all are for which she gets the wage, is treated in the continuous employment.
All right. Quick closing comment from you, Mr. Bhattacharya.
Yeah, one major benefit you asked for the benefits is from this gratuity law amendment is the government has recently come out with a fixed term employment scheme under which companies can actually have employees on a fixed term. Now, those employees, as being under a fixed term, will also be entitled to gratuity, and my understanding is that even if they don't complete the minimum number of years of 5 years under the fixed term employment scheme, they will get the benefit of those gratuity benefits. So, therefore, I think even the fixed term employees are not excluded from the purview of this amended law. So, in that sense, as long as you are either you are a permanent employee or even you are a fixed term employee, you continue to get the benefit.
Okay, all right. On that note, then we'll have to call it a wrap on this segment of Policy Watch. Thank you to Dr. Onkar Sharma and Mr. A.K. Bhattacharya for joining me on the program and putting things into perspective for us. It's time for a short break now. Still to come, the government begins process of selling enemy properties and issues guidelines for the same. We'll take a closer look on the other side. Stay tuned. We'll be right back. Welcome back. You're watching Policy Watch with me, Frankrouzan Perera. In a bid to enrich its coffers by about 1 lakh crore rupees, the government has started the process of monetization of more than 9,400 enemy properties by issuing guidelines and directing the Office of the Custodian to submit a list of all such movable and immovable assets within 3 months. The Ministry of Home Affairs has also constituted a valuation committee at the district level headed by the district magistrate and an inter-ministerial disposal committee headed by an additional secretary so that the process could be completed in a time-bound manner. The move comes after the amendment of the Enemy Property Amendment and Validation Act of 2017 and the Enemy Property Amendment Rules of 2018, which ensured that the heirs of those who migrated to Pakistan and China during partition and afterwards will have no claim over the properties left behind in India. In our next segment, we will discuss the government's decision to sell enemy properties. Joining me on the program now are Sandeep Mahapatra, advocate of the Supreme Court, and Himanshu Vats, senior editor of the Economic Times. Thank you to both my guests for joining me on this edition of Policy Watch. Sandeep Mahapatra, I'd like to begin with you. Of course, first and foremost, let's try and understand what these enemy properties are and what is it that the government has changed so as to ensure that it can sell these enemy properties.
This is a very valid point and very valid question. When the wars with China and Pakistan happened in the 60s and early 70s, the government of the day came out with an Enemy Property Act under the Indian Defence Rule. So during the war, the properties those were belonging to the enemy, meaning there were those who left India and went to China or Pakistan, their properties were acquired by the government. But since these were wartime measures, an act was enacted in 1968. And in that act, it was provided that those who left India and went to Pakistan and China, their property will be seized. A custodian will be appointed. He will be acting as the administrator of the property. He was to merely act as an administrator, nothing more, nothing less. But it led to various issues later on. And one such issue came to the Supreme Court, and the Supreme Court in 2005 gave a verdict saying that the role of the custodian is only merely as a trustee. He cannot sell it. The rights of the legal heirs may be asserted. So, this being the position, the government in 2010, they introduced an ordinance in the parliament, but that lapsed. And that ordinance was again repromulgated in 2016 over five times. And that led to the passing of the act in 2017. The 2017 act essentially says that those who left India and went to Pakistan for that matter or China, their legal heirs also will be treated as enemy subject. That is number one. Number two is all those properties which may have been sold between 1968 and 2016 for the first time when the first ordinance of the second series were brought will be treated as invalid, and therefore it will vest in the custodian, and it gave the power to the custodian to sell those properties and realize the amount from the property. One aspect that needs to be pointed out is that apart from all this, the Act of 2017 also makes a provision in Section 18 of the Amendment Act, the Amendment Act that came into picture in 2017, is that if somebody is aggrieved of a decision taken by the custodian of the property being vested with the custodian, he can make an appeal to the Government of India, and the Government of India will give a reasonable hearing to such a person to find out whether or not he is a legal heir or not, and give a judgment. And if it is found that the property has been wrongly vested with the custodian, it will revert back to that person. Sure. That is one very significant aspect, I would say, that has been brought in this in the Amended Act of 2017. Apart from that, another explanation that has been appended in Section 2, Clause B of the 2017 Act is that if somebody who has been a legal heir of an enemy has got the rights to that property by virtue of law, then his status will not be disturbed. So that is another significant aspect. So the controversy that is being sought to be created is that, look, many people will be divested of their property, even if their forefathers went to Pakistan or for that matter China. These guys are Indian citizens and they are being discriminated. That is a wrong thing to say, because what has happened is over the last 50 years, these properties have been grabbed by encroachers and they are claiming.
Sure.
Wrongfully claiming.
Sure. So there have been several wrongful claims, is what you're suggesting.
And that has led to this passing of the Act, and that is trying to remedy a situation which has occurred in the last 50 years.
Okay. Himanshu Vats, let me bring you into the picture now. What are the kind of monetary implications really from the government as far as selling of these enemy properties are concerned?
I think the preliminary estimate that the government has given is it could be worth 1 lakh crore. That's what the media report said. And there are, I think, a total of around 9,000 properties, mostly in Uttar Pradesh and West Bengal. So that could be a good source of revenue. It is significant. There are problems, like our fellow panelists have indicated, that many of these are encroached and many of them have been occupied, and there will be attempts to put judicial hurdles in this. A political situation is also sought to be created. I think the government needs to very firmly set all this aside. It's not just the amount of money that will be raised. This is a matter that needs to be put to an end. And this is not something unique to India. Bangladesh has done it.
Is it going Pakistan to be difficult to put it to an end, though?
Yeah, but the firmness with which the government is moving, I think this process has to begin. And particularly, with the amendment, the powers which the custodian now has, the government now has to actually sell it. That's pretty important. In other countries like UK, US, Canada, World War time, they set up such offices and they did their job and they wound up in most of these countries. So I think we have to look at it in a wider sense. This is an issue that needs to be resolved. More than 70 years after independence, you cannot be having dispute that somebody's great-grandfather owned this property. There have been some very silly things that have happened in the past also, according to what's there in the internet. Somebody in Pakistan claimed 1/3 of Agra, including Taj Mahal. Somebody claimed half of Muzaffarnagar. These kind of things have happened. All this needs to be put to rest. These properties need to be disposed of.
And sooner the better.
Yeah.
Okay. So, how do you see the government, Sandeep Mahapatra, going about doing its business of disposing of these properties, and what major hurdles do you see coming up?
Look, the procedure that has been set out by the government is that a valuation committee will be appointed at the district level. With the district magistrate as the chairman, there will be a vice chairman. In India, and as a lawyer, I have seen that the valuation of a property is one aspect and very critical aspect of any execution proceeding. Number one is that. The second aspect is the tendering process, that you call from the public tenders, and so that you get the highest tender and money from that property, and that takes time. If a tender is floated and you don't get the the rate which is at par with the valuation of the property, then that tender has to be scrapped. So I see a problem area in this aspect, that when you float a tender, whether the amount of money that you will be receiving as a tender or a bid will be sufficient with the valuation, and number two, whether the sale will happen or not. Because many a times we have seen that even after court decrees, the execution of the decree is the most difficult part. And there is a saying amongst lawyers also that yes, maybe our clients may have got a decree, but it is paper decree, because at the end of the day, the execution cannot take place, because the executioner is not allowed to enter the property and take stock of the situation. The kind of political praha that is being built about on all this issue, there is a possibility that even if it is let out for tender, the tender process may not be completed, the sale process may not be completed. That is one major hurdle that I foresee. And secondly, I as a lawyer would foresee that there would be legal challenges where the act itself, saying that this act is not as per the constitution, that is another challenge. But as a lawyer, I also would say that there are enough number of safety measures that has been inbuilt in the Act of 2017, and that will take care of many things, because if the custodian is vested with a property, firstly you can go to the government. If the government do not agree with you, you can go to the High Court and file an appeal before the High Court, and then the Supreme Court of course is there. So safety measures are already there. It is a step in the right direction, I would say, and the sooner it is done, as Mr. Himanshu has pointed out, the better it is, because it is merely 10,000, less than 10,000 property. In a country of more than 1.25 billion, 10,000 properties are nothing.
Sure.
So it is the manner in which it has to be implemented, and politics should be kept out of all these things. Here and there could be some issues, but then the underlying thing is, historically world over, this is the trend. In fact, Pakistan seized all the properties of Indians who fled Pakistan in 1971. And those who are giving an argument that this is targeted against a particular community, I would like to ask them, if that was the case, then there was no need for the 1968 Act itself. Meaning thereby that somebody left for Pakistan, and his progenitor or the next generation will still happily be enjoying that property.
Sure.
So there was no case for 1960 Act itself, if
right.
that argument is to be taken into consideration. So
sure.
Overall, this is a right step in the right direction, and I would agree with Mr. Himanshu again that everything has to be put to rest.
Sure. Is there a time frame, Himanshu, where we can see this being settled, a realistic time frame really for this whole issue to be dealt with?
That will be a tough one to estimate, because there are going to be challenges, like you just, as a lawyer, mentioned. There will be problems of tendering, valuation. Getting the valuation right in 3 months itself is a slightly ambitious target, because valuing property is, there are two sides to it. One way is a value of a property is the value the market is ready to pay. The other side is, no, this is such a prime property, people got scared of bidding, So these are kind of things that have to be kept aside. You have to go in a very determined manner. And, if there is support of the state governments, centre's determination is pretty clear. I think it can be done in a couple of years also. But, you can take nothing for granted in this. There will be all kind of obstacles, arguments, and one argument, which can be applied to anything in India, that this may be misused. Because if something that can be misused should not exist, then we should have no government, no police, no judiciary, no media, no television. Just because something may aggrieve somebody or may be misused. So those are the kind of arguments that have to be kept aside. You have to look at it in a very firm and practical thing that, okay, this is an issue we need to put to rest.
Sure.
See what are the easier properties to deal with. Don't get lost in valuation, because many of the properties, if somebody has a house in 1947, that's not likely going to be a very posh area today.
Yeah.
So the authorities will have to accept that.
Right. Right. Okay. Quick closing comment from Sandeep Mahapatra before I close the show.
Look, this issue has been there, and there was a need to bring an ordinance, and therefore the previous government in 2010 also brought an ordinance. But the lack of political will, I would say, prevented that government to act on this. The present government is determined to act on this and put to rest an issue which has been boiling for the last many years. Once in a while, you would be listening to, or you will be hearing about some, next generation coming about and saying that, look, I own this property, because there was a case in UP who said that my forefathers owned half of UP and Uttarakhand, and therefore I should be compensated. In this act, it has been provided for that if the enemy property is occupied by somebody, the sale proceed, a percentage of the sale proceed will be given to the occupants who were till that day were occupying. So all these safety measures are there. Rather than making a political or any kind of an issue, it has to be seen as a legalistic point of view and a practical aspect or a practical viewpoint, rather than raking out controversy. Because after the bill was passed, many articles were written by some prominent parliamentarians also. And I remember a parliamentary wrote in Reuters also, saying that this is against a particular community. So that kind of a tendency has to be avoided for this legislation to reach its conclusion, logical end.
Okay, all right. On that note, then we'll call it a wrap on this edition of Policy Watch. Thank you to Sandeep Mahapatra and Himanshu Butts for joining me on the program and putting things into perspective for us. That's it from me. But before I go, of course, you can always send your suggestions and feedback to our email ID policywatch.feedback@gmail.com. You can also tweet to us using our Twitter handles at FRP09 and at Rajya Sabha TV. That's it from me. See you again next time.